Hello, my name is Albert Paulson. I'm a teacher of AP Government at West Windsor Plainsboro High School North. We have here two students who will be answering questions on behalf of the petitioner side. They are Sid and Rithika. The first question is, at what point does a police officer affect a seizure for purposes of the 14th Amendment?
May it please the court. So first on this question, what we're going to do to discuss it is break it down into two clear subparts. But both of these subparts rely on a primary contention that we're going to make, which is that the original meaning of seizure, according to the Fourth Amendment, included common law arrests, which did not require the suspect to submit in response to any sort of intentional physical force. Now on to our two subpoints. First of all, is that the original meaning of seizure in and of itself arises from common law of arrest. And second, at common law, a police officer's use of physical force against any person with an intent to restrain was an arrest, regardless of whether the person escapes in the first place. So, on that first point of how seizure arrest arises from common law of arrest, we look to United States v. Watson, in which it says that there is no doubt that by the reference to the seizure of persons, the Fourth Amendment was intended to apply to arrests. Now, under the second contention that we're making about common law being in the need of arrest, regardless of whether the person has escaped, we look at multiple different Supreme Court cases, but primarily Hadari, in which there is no doubt that by reference to seizure of powers, the Fourth Amendment is not only intended to apply to arrests, but generally perpetuated the oppressive practices of allowing the police to arrest and search on suspicion. Furthermore, we see Henry v. United States and Etnick v. Carrington extend this impact on how arrest and seize can be used interchangeably in the context of this question. So that concludes our discussion of question number one.
Okay. Question number two. What is a common law arrest?
The sources collected by Hodari D. confirm that in a common law arrest, an arrest is effectuated by the slightest physical contact. According to the court's decision in Hodari, an officer effects an arrest of a person to whom he has authority to arrest by laying his hand on him for the purpose of arresting him, though he may not succeed in stopping and holding him. This essentially means that a common law arrest is any arrest with a warrant, regardless of whether the offense succeeds or not, or whether physical force is successful in detaining the suspect or not. At common law, warrantless arrests of people who have committed a breach of the peace or who have committed felonies are permitted. So even if there is not a warrant for the person to, or the policeman to arrest the person, they can still do so under common law. Therefore, a common law arrest includes all the possibilities whereby a person could be detained by physical force or they could have escaped. This relates to our argument that the excessive use of physical force in Torres v. Madrid was unconstitutional because it constituted a seizure, because under common law, the arrest did not have to be successful, meaning the person did not have to be detained permanently in order for it to be a common law arrest. Therefore, the arrest of Torres in Torres v. Madrid was a common law arrest and is, as we've explained, a seizure under the Fourth Amendment.
Okay. Well done. Question number three. Did California v. Hadari D. hold that the Fourth Amendment encompassed the common law definition of arrest?
To begin our answer to this question, we would like to first define what constitutes a seizure of the person. Just as to constitute an arrest, the quintessential seizure of the person under the Fourth Amendment jurisprudence says that there must be either the application of physical force, however slight, or where that is absent, submission to an officer's show of authority to restrain the subject's liberty. So, in most purposes of common law, the word connoted not merely by grasping or applying physical force to the animate or inanimate object in question, but actually bringing with it any sort of physical control. Under this definition of common law arrest and the definition that my partner provided to you in the previous question, it is quite clear that in California v. Hodari, the Fourth Amendment did encompass a common law definition of arrest. This also goes back to our argumentation that we provide you on our first argument, subpoint B, where we use the common law in deciding how to define seizure and arrest. In California v. Hodari D, the court considered whether at the time Hodari D dropped the drugs, he had been seized within the meaning of the Fourth Amendment. To do this, they looked to common law and elaborated in the William and Mary Bill of Rights Journal. To understand the Supreme Court's current Fourth Amendment doctrine, it is critical to understand the common law. Therefore, we must look to common law in the case to define a seizure, which directly falls under the jurisdiction of California v. Hodari, and as a consequence, answer the question quite clearly that under California v. Hodari, the Fourth Amendment did encompass common law definition of arrest.
Okay. On to question 4. Was the police officer's shooting of Torres reasonable?
We, the petitioner, believe that the police officer's shooting of Torres was unreasonable for 2 main reasons. First, the police did not have a warrant or a probable cause to shoot Torres, and second of all, the police's shooting of Torres was a seizure, which is unconstitutional under the Fourth Amendment. First, the police did not obtain a warrant from the judge in order to actually pursue Torres. They also didn't have sufficient probable cause in order to even shoot Torres, therefore making their shooting in the first place unreasonable. However, the more glaring issue we see here is that the shooting of Torres was itself a seizure, and a seizure is unconstitutional under the Fourth Amendment. A wealth of historical sources confirm that the Fourth Amendment protects individuals from the unreasonable use of physical force by law enforcement in undertaking arrests, regardless of whether the force immediately brings those individuals within the officer's control. As we mentioned in a previous question, the original meaning of seizure in the Fourth Amendment includes common law arrest, which did not require the suspect to submit in response to intentional physical force. In other words, it does not require the suspect to be successfully detained in order for an arrest to be constituted as a seizure. The Supreme Court has long recognized that the Fourth Amendment, since its inception, has protected against unreasonable searches and seizures in accordance with the common law meaning of these terms. Again, looking at Hodari's precedent, they directly consulted common law to explain the meaning of seizure, and thus concluded that a seizure exists whether or not the suspect is successfully detained if there is unreasonable or excessive force used against them. The gun shooting was essentially excessive force used against Torres, as we've said in earlier arguments, and we claim right here, because the shooting a gun at Torres, who was simply running away, was clearly an excessive use of physical force. And under this meaning of common law and the direct derivation of the Fourth Amendment by common law, we can see that by shooting Torres, the police officers were acting unreasonably and they were seizing Torres, which is unconstitutional.
All right. Our 5th and final question. How should the original public meaning of the Fourth Amendment affect the analysis in this case?
From the inception of the Constitution, the framers understood that a common law trespass on property is a Fourth Amendment search. They essentially designed the Constitution and specifically Fourth Amendment based on common law because in the 18th century, common law was the most ubiquitous type of law across both the United States and Europe. So the public meaning of law and the public meaning of constitutionality around that time was based on common law. As Samuel Johnson elaborates in his Dictionary of English Terms, a common law arrest is a seizure. He directly substitutes both of the terms for each other. And as we've demonstrated in our previous questions, a common law arrest does not have to be successful to be a seizure or to be unreasonable. So, using the original public meaning of the Fourth Amendment, which is essentially the meaning of common law, we have to analyze this case based on the precedent we see of common law. And again, the case that most clearly demonstrates this is California v. Hodari D. In this case, the court considered whether at the time Hodari D dropped the drugs, which was the charge that he was indicted with in his court case, if when he dropped the drugs, if he had been seized within the meaning of the Fourth Amendment, it would be termed constitutional or unconstitutional. In order to decide whether he was actually seized, the court looked to common law. In the William and Mary Bill of Rights Journal, the authors elaborate that to understand the Supreme Court's current Fourth Amendment doctrine, it's critical to understand the common law. Additionally, the doctrine of original intent holds that we have to look at the framers' original meaning behind designing the Constitution in order to understand public meaning and the way we interpret the Fourth Amendment today. Because all of these original intents reflect the meaning of common law, we must use common law to evaluate the case we have today, and that means that we must consider the excessive use of physical force by the police officers on Torres to be unconstitutional because it's a seizure under common law.
Okay. Thank you very much for your answers to those questions.